Hello and welcome to Verdictum. I am Ananya Singh, and today we have with us a very special guest, Senior Advocate Mr. Vijay Hansaria. Sir is a well known constitutional expert and started his journey as a lawyer in 1980. In 2002, Sir was designated as Senior Advocate by the Supreme Court and has held important positions such as the Vice President of the Supreme Court Bar Association and member of the National Legal Service Authority. He has authored many books on constitution and juvenile justice. Notably, he is assisting the Supreme Court in a large number of cases as amicus curiae. This includes a PIL regarding expeditious trial of criminal cases against MPs and MLAs and their permanent disqualification upon conviction. And today, that is what he is going to talk us through. Welcome to Verdictum, sir. It's a pleasure to have you with us today.
Thank you. It's a pleasure for me too.
So, sir, I'll start with the current scenario. Unfortunately, there has been an increasing trend of criminalization of politics. How would you say it affects the democratic functioning?
Yeah, as you started saying, unfortunately, I also believe it. And I started in the court that unfortunately, we have more than 5,000 criminal cases against politicians. And we have 4,778 legislators in the country, which includes all MLAs and all MPs. So criminalization is all pervasive in our democratic functioning today. So you asked me, how is it affecting our governance? See, what is democracy? Democracy is rule of the people, by the people, for the people. Now, when we have such large number of persons on the parliament and legislatures, we have rule not of the people. We have rule of the people involved with criminal antecedents. We have rule by the people, not by the people, ordinary people by which democracy was conceptualized. We have rule by the people who have criminal cases against them. And of course, rule is for the people, common man are there, who would they be ruling it? So it definitely affects the whole foundation of the democratic setup of any country.
Sir, convictions presently lead to a bar of a maximum of 6 years. Is that period not enough? You are pitching in for a ban on politicians when convicted for life. Why is that, sir?
See, presently, the law as it stands, we have 3 categories of offenses which incur disqualification of the Representation of People's Act. There are about 44 laws for which conviction of even fine is sufficient to disqualify. I'll come to the period next. There are 4 laws such as essential commodities or food adulteration where conviction of 2 years incurs disqualification. For all other offenses, you have disqualification only if you are convicted for 2 years or more. But in all these cases, there is a common thread is that disqualification is for a period of 6 years of the release. Please visualize persons with murders, committing rape, gang rape, are released, and after 6 years, they become our lawmakers. They can become theoretically, I'll not say theoretically, we have people, 40% of our legislators have criminal records today. So we have people who is convicted of murder. I'll give you a live example of rape, and they become our MLA, they become MP, they can become chief minister, and they can become the law minister or prime minister of the country. That can't be the law of our country. And I'll give you a live example. Say in the Bilkis Bano case, the offense was upheld up to Supreme Court. 11 persons have been maybe 12 or 13 persons have been convicted for murder of 11 persons, gang rape of 4 women, including pregnant women. They have been released 15th August 2022. So in 2028, their disqualification ends, and in 2029 parliamentary election, each one of them can become a lawmaker for our country, a minister or a law minister, or even a higher minister. That is absolutely aberrant. That's not acceptable to the people of this country. That's why I'm pressing that this part of the law is manifestly arbitrary, especially when you compare. You can't become a class 4 peon. If you have a conviction, no one will give you a private employment even. You can't have a government employee with a class 4 PIN. I have seen cases where a conductor convicted for 2 rupees bribe, that means he is not issued a ticket, he is convicted, he is expelled, he can't get a job. And in a country like this, we can become the prime minister, but he cannot have a class 4 PIN. That's not acceptable to the country.
Sir, as you just talked about conviction in other cases, like when civil servants in the case of conviction are sacked, there are also several laws that provide for permanent disqualification of officers of the Vigilance Commission and Lokpals and Lokayukts. You also mentioned the Bilkis Bano case, wherein the convict was criticized for practicing law after completing his
Yes,
sentence.
yes.
Uh, when such is the scale for others in a legal as well as a social setup, do you think that politicians are placed on a higher pedestal in this regard?
Unfortunately, that is the case. There should have been we call them public servant, but do you and me or any politician believe they're public servant? They're public masters, not they only. And for again, I don't want to use those strong words. Anybody connected to the politicians at the lowest level, suppose a municipal councillor, his all brothers, his officer, his family members, his friends, they think that they're the political masters of the country. They're not public servants. We use the word public servant to grant them that they have an immunity, they require sanction for prosecution because they are public servants, but ultimately they are public masters. So according to me, the politicians, the ruling class must believe, and their action must justify that they are public servant. They are supposed to serve the people of this country, and for which we are electing them. That mindset needs to be changed.
So, you talked about them being a public servant. So, the Supreme Court has discussed in the A.R. Antole case about two abortive attempts. So, one was in 1925 when Legislative Bodies Corrupt Practices Act was introduced to make corrupt influencing of votes by MLAs a penal offense. Another one in 1964 when the Samthanam Committee recommended a code of conduct for MLAs, and it was allegedly to save them from the specter of corruption, but none included them under the definition of public servant. Do you think that lawmakers have not been keen enough to stop such corrupt practices?
See, we have corrupt practice definition in the Representation of People's Act. That's only for the purpose of disqualification or election at the time of election. That for corrupt practice, if you have involved in corrupt practice, your election may be set aside. It can be challenged on that ground, but that takes years and decades. Most of the time, by the time an election petition is decided, the term of election is over. That has not worked. So corrupt practice for the purpose of Representation of People's Act has not worked. So those offenses, those corrupt practices must become a part of disqualification, because they are not disqualification today. They indulge in corrupt practice during election purpose. That is an offense. By the time the offense is decided, by the time election petition in which the allegation of corrupt practice is decided, the election period is over, and by the time it becomes infructuous, and then again they come and elect the next time again. So it does not work according to me.
Sir, sadly, the definition of public servant remains essentially the same under the new Bharatiya Nyaya Sanhita or the new criminal laws.
Yes.
Are you of the view that now the interpretation of this particular term needs a wider coverage?
So public servant is a wider coverage under the old and the new law also. It doesn't make any difference, even if, because all the members, even we are now, the judgment has been reserved 2 days back. All the MLAs are held to be public servant. They are not normally a public servant when there is a master, because all the MLAs and MPs have no masters as such. But the Supreme Court in Narasimha saw that they are public servant, and you require sanction of the speaker or the chairman to initiate prosecution or to file a charge sheet and to prosecute them. In that case, of course, when you have come to that, they are public servant. So they are entitled to the benefit of being public servant because they cannot be prosecuted without a sanction. For a common man like you and me, we can be prosecuted for wrongful prosecution for anything said, etc. But for a public servant, you require a sanction of an authority. For an MLA and MP, the authority is the speaker or the chairman of the Rajya Sabha, or in case of state government, the speaker of the Legislative Assembly. So definition is wide enough to cover all the MLAs. I don't think any further enlargement of definition is required.
Sir, as you mentioned earlier, that there are over 5,000 cases against MPs and MLAs that are pending across the nation. What suggestions would you like to make for expeditious trial of such cases?
See, Supreme Court has been monitoring this last 5 years, and I've been actively assisting the Supreme Court and telling the Supreme Court you must do it. Court has done it, passed some orders, but when it becomes a very severe injury or very severe infection to the body, it requires surgical treatment. For surgical treatment, you have to have the very strong measures, and strong measures. Supreme Court judgment is reserved on that. My submissions are there. I am saying the problem is that they can drag it. We have limited number of judicial officers, though they are a special court, but the same judge is a special court MPMLA, he is the special court POXO, he is the special court for ST cases, and he is special court for so he has a different hat. So he just put a hat, he becomes a special court MPMLA. So same judge, his board is very tight. What I have suggested one thing, the priority has to be that the public servants, especially our legislators, they may be innocent. I don't say that all of them have been dealt. There may be innocent prosecutions against them. And many of them, let me tell you, and out of 5,000, I think more than half are those cases where there are for 144 violation, where stage a dharna, and there is a criminal case against them. And they will be let off with fine or warning, etc., under Section 188 IPC. So many of those cases are of trivial nature, where they have whole demonstrations which they are entitled, everybody of us, MPs, ML are equally entitled. So they must go. But they are also are pending for various vested regions of the person's party in power. So according to me, the cases of these MPs, MLAs must have priority. A particular judge must deal with these cases on a day-to-day basis, no adjournment whatsoever, be it the public prosecutor or the accused. I have given certain suggestions. If the public prosecutor does not cooperate, inform the chief secretary and get a new public prosecutor. If the accused does not cooperate, issue non-bailable warrants against him and get him. It will all happen. See, it's a matter of 1 year. In 1 year, if the direction is that the case judges who are handling MP, MLA cases or those presiding over MP, MLA courts will do those cases only till such time these cases are there. Then perhaps we can get a good result. Not until then. Let's hope my submission to some extent is accepted by the Supreme Court, because the concern of the Supreme Court is also, if all the judges do this, what will happen to other cases? That's an equally concern, but you have to prioritize the concern. That's what my request is to the Supreme Court, and order is pending.
So, you have made the submission of setting up special courts. How would setting up special courts to decide such cases solve the problem? I think you have partially answered it, but just to elaborate a little more on it.
See, special court is for a particular category of cases. We should have the idea of special court is that you have a judge dedicated to that case. Now we have only a hat. The same person is having special court of different colors. It doesn't solve the purpose. Merely by changing the nomenclature, it does not. We don't have sufficient judicial infrastructure. We don't have sufficient number of judges. The judges work very, very hard, according to me, much more than anywhere in the world. So if the same judge is required to do so many functions, he is not able to devote sufficient time. And all these corruption cases or cases where the MPs, MLAs involved, there's a lot of pressure from the lawyer side like us. There's a lot of pressure from the public. There's a lot of non-cooperation from the prosecution side. The witnesses are afraid of coming and deposing to the court. But be that as may, without evidence, there cannot be any trial. So my emphasis is that special court, dedicated court, I'll just call it not a special court by nomenclature, if there's a dedicated court for this category of cases. And 5,000 is not a very big number. We have 2,500 judicial officers in the country. Each one of them, if they on day-to-day basis, they conduct it and no adjournment whatsoever, perhaps we can get a better result after 1 year.
Sir, there is an alarming figure that indicates the level of criminalization in politics. And yet there is use, or if misuse, if I may say so, of Articles 105 and 194. How do you suggest the parliamentary privileges be exercised? especially in the aftermath of cases like Sita Soren versus Union of India?
Can we think even remotely? I commit an offense and I claim privilege. Privileges for speaking in the house, privileges for voting in the house. Privilege is not a license to commit a crime, accept a bribe. That Narasimha Rao judgment absolutely wrong. Absolutely wrong. They say bribe giver punished, bribe takers, they can pocket the money and they cannot be punished. That's a completely wrong. We had ideals in 1950. Nobody in the Constitutional Assembly thought that there would be so many criminal cases against our elected legislators, but unfortunately we have failed. So this judgment is bound to be reversed according to me. And please see, Ananya, this problem is not regarding bribe only. That's what I have submitted. Suppose you have a meeting with an unlawful organization before there's a voting takes place in the house on an important law on a government to defeat, and there are some unknown organizations meet or connive or conspire that a particular law must not be passed. So the member goes and meet them, have a deal with them, comes and vote as per their term, and he is immune. How can this be? This is something very, very serious. So that's what globally we have found. Of late, the trends have changed because that is the requirement of the day. Today, when we have so many criminal cases against the politicians, against the ruling, against the sitting members, claiming privilege, it is very easy. What the Supreme Court in the Narasimha Rao says, if there's a nexus, that means you have taken the money and you have voted, so there's a nexus. Nexus is theory has to go. That has to be in performance of your duty. If you say anything in the house, you immune. Presently, one of our MPs have said something which would, if he would have said outside the house, it would have been offense. But if he said inside the house, that is protected. Anyway, some extra protection is required. So 105 and 194 privileges are not meant for, is not a license to commit an offense. That's what we have said, and we are waiting for the judgment from the Supreme Court, from the larger bench.
So another buzzing question is, why is the constitutionality of Section 8 of the Representation of People Act in question? Please highlight on that.
As I said, Section 8 disqualifies persons from contesting elections if we have committed 3 categories of offenses. I've said some categories like UAPA, some categories like sati glorification, some committed like corrupt practice or so. Even if you are convicted for fine, not even a day's sentence, you are disqualified. But unfortunately, they have not seen the parliament again, because the lawbreakers become the lawmakers, they will see their interest, has said that even if you have committed the most heinous crime in the society, and you can, that we have a living example of Bilkis Bano, you can again come after 6 years of release and become qualified. That is the law since 1951 in the Representation of People's Act. But that needs, as I said, that the law was made by the same Constituent Assembly, 19 Representation of People's Act, which framed the Constitution, and they could have never imagined that any such circumstances will arise. But such circumstances arise, the courts must be alive to the current realities. And with the current realities, these provisions is manifestly arbitrary.
So talking about the current realities, as you said, there is also a practice of proxy representation, which is very old in India, be it Gram Pradhan, Mayor, MLA, MP, CM, all of those things. We have seen perfect examples of this practice. Do you think that family members of disqualified elected representatives should also not be allowed to contest elections?
I don't think so. You can't blame the children because of the mother's crime or the father's crime. That will not be fair. I have no control what my parent has done. I have no control how he behaves. We have seen totally different, they are individual persons. Legacy is not to hope they say we don't follow the path. They become the lawmakers. And we know people we see in various serials also. the children sees, no, what my father or my parents are doing. It's not supposed to be. They have seen from the close quarters. Good senses prevail. So we cannot, there is no question of making the children suffer for the wrong committed by their parents. Then it should not be disqualified. There is no question of that.
So, but
And there is no such contemplation.
But how would you say you can regulate the practice of proxy representation?
See, there is a practice in the sense you get a initial boost. Ultimately, it is the voters who decide. You get a platform which a normal person will not get that platform, which you get a platform to start with. That's another debate which is going on, whether the proxy representation in the sense that the children or their wife becomes. So if the wife is capable enough and people has voted him, then I personally don't feel that there's anything wrong in it. Ultimately, you get elected because people votes for you. If the people votes for you, whether you are a son of a elected representative, son of a minister or not, there are many examples where the children of the ministers get defeated, don't come into the election. So to make them disqualified, of course, they get a initial edge, initial support, initial foundation that is there in every case, which is by birth you get some benefits which you cannot deprive the person.
Okay, but just to a little bit of highlight on this, your remote control should not be in the hands of another.
I agree. There should not be a remote control governance, remote control power centers, etc., which we had seen in the past, unfortunately, in our country. But then that is, suppose someone within the family, that is, I don't think if you have a remote and that person is willing to dance to your remote, you can't help it, whether directly or indirectly. So that's a very difficult thing to say that, all right, you will not have the remote. And it's a question whether that person is dancing to a remote. That person must, once elected, once he say that I feel that, yes, I am representing these people, I should do what the people needs to do. People do expect me to do. And if it does that, that's fine. But ultimately, we have words like high command in our country. In all political parties, there are always high commands. So I personally always feel that when it is left to the choice of it, who will become the chief minister, high command in Delhi will decide. Why should he decide? In a state election, the legislators must decide who will head them, not the high command, someone. But unfortunately, that high command thing is there for every political party. It's not of one political party.
With that, I'd just like to thank you for sharing your views with us, sir, today. And this certainly was a very fruitful session for me and for our viewers. And thank you so much for joining us today, sir.
Thank you. It was my pleasure too. Thanks a lot. Bye.
In a new India, where we need to weed out corruption for a better tomorrow, it is a very sorry state of affair that our representatives, our parliamentarians, are often the ones indulging in corrupt practices. I will leave you to ponder upon that note. This is Ananya Singh signing off. Thank you for watching Verdictum, and do subscribe to us and download the Verdictum app on iOS and Android for latest legal news.